What we know so far about changes to home education law. Whilst the Children's Wellbeing in Schools Bill is now law, nothing has changed yet. Consultation about new home education guidance before anything changes. The current guidance is something local authorities should follow. New guidance will be something local authorities must follow. If you sign up to the educationalfreedom.org.uk newsletter, you'll be notified when the consultation is released. Home education guidance will determine how local authorities are to inquire about the home education provision. Enquiries about the education are separate to the rules from this bill, which is now an act. The Home Education Register is going to require the name and address of all parents, details of those providing education over a specified time, details of the child and any protected characteristics, including religion and gender, estimation of time that each parent provides education, estimation of time that education takes place elsewhere, and anything else the local authority wants. If someone else is providing education over a yet-to-be-specified amount of time and the local authority makes contact with them, they will be expected to provide information about the child. Full specifics have not been declared yet. Known home educators will be required to register within 15 days of the register going live. The specifics of how this will happen are yet to be determined. Unknown home educators will be required to register. If you don't and you are found, the local authority will be able to conduct formal and intrusive enquiries with an assumption of the education being unsuitable. Within 15 days of registering, the local authority must consider the environments in which the child lives. This could be more than one house, and the local authority can ask for a home visit to do this. Requests to update the register can be made every 3 months and will be done at least once a year. This is separate to enquiries about the education, which are yet to be determined. Refusing a home visit can be used as a reason to believe that education is unsuitable. Special considerations will be taken into account, but we don't know the specifics. Consent to deregister will be required if your child attends a special school. Also, if you've had a child protection plan in the last 5 years, if you've got current Section 47 social services enquiries happening at the time of deregistration. The child must remain in school whilst the decision is made. If the consent is refused, the local authority do not have to consider any new requests made within 6 months. The local authority will be allowed to decide what is in your child's best interests. This can be used when deciding if you can deregister or if school attendance processes should be started. There will be new processes for formal enquiries. Current Section 4371 formal notices to satisfy will be replaced with a preliminary notice. This can be served if social services become involved, concerns about suitability of home education are raised, or the local authority decides school would be in the best interests of the child. The local authority may ask for a home visit to make a determination. A school attendance order can be served if the local authority are not satisfied. There will be heavier penalties if you refuse to abide by a school attendance order. If you believe the local authority have unfairly served an SAO, you can allow the case to go to court. However, if you lose, the fine is higher than currently and there will be a risk of imprisonment. A pilot scheme will run in up to 30% of local authorities. A mandatory meeting will be required after receiving your deregistration. The child must carry on attending school until the local authority inform the school that the meeting has taken place. There's no timescale for this meeting or the notification, which could leave children in vulnerable and dangerous situations in school. There is a small section about support in this new Act. The changes will encourage local authorities to provide support if a home educator asks for it. However, the local authority are not obliged to provide anything at all. We know a lot of that is very scary, but here's what Educational Freedom are going to do. I and my team are going to make sure you have everything you possibly could need. We will update the website and provide extensive and comprehensive information to cover all angles of the changes. This will include new template letters, new advice on how to protect yourself, advice on how to ensure your local authority doesn't overstep, and everything else that you're used to receiving from us. We are not going to let you go through this alone. So please ensure you are fully clued up. Sign up to the newsletter, make sure you get every piece of factual information and digest it and understand the law. It is going to be absolutely vital in protecting your right to home education.